the Cybersecurity and Compliance Podcast with Craig Petronella. Learn about the most current IT security threats in ransomware, phishing, business email compromise, cybercrime tactics, cyber heist schemes, social engineering scams, as well as hints and tips from leading professionals to help you prevent hackers from penetrating your network and dropping ransomware or malware payloads. This podcast will arm you with the best info to defend your network against the latest cyber crimes. Don't forget to like and subscribe. And now, here's your host, Craig Petronella.
You're listening to Cybersecurity and Compliance with Craig Petronella. Visit us online at petronellatech.com.
Well, hi, Lisa. Welcome.
Hey, Craig.
Are you excited to talk about GDPR today?
Oh, I'm excited about GDPR every single day. Sure.
So introduce yourself, please, so the audience knows who you are.
Okay, sure. My name is Lisa Shasteen, and I am a co-founder of the Shasteen and Percy law firm here in Tampa, Florida. And we pretty much focus on data security and privacy 100%. That's what we do, and we represent quite a few tech companies as well as people who are having some issues with privacy and security of information, and we do things with social media influencers and the like. So we're all digital all the time.
Awesome. So tell us, from your perspective, I bet a lot of people have heard GDPR or that name. So what is it really? What does it mean? What do people give us, like, your version, the short one, of course.
Well, I don't know if you want my real version or the official version, but what GDPR is the General Data Protection Regulation. And it actually went into effect in the spring of 2018. I believe it was May 25th. And in any event, I remember that year very well, because about 7 days later, we got a call from a client who's a very wonderful group. And they had a data breach. And unfortunately, they were doing business all over the world from a location here in the United States. They didn't even have any offices in the EEA, the European Economic Area countries. So it's not just the EU, it's a few more that didn't join the European Union. So they needed some help, and under the General Data Protection Regulation that had just gone into effect, or the GDPR, they had the obligation of reporting their data breach within 72 hours of discovery of that breach, because that is the GDPR standard. And they called us 36 hours in. So I said, yay.
Wow, they give you a lot of time.
Yeah, I'm glad we weren't rushed, is basically my response. I was signing an engagement letter with them at their offices at 7 p.m. and saying we really have to get started now. Yesterday, with the forensics team, who was already on the scene, thank goodness. And, so the thing about GDPR and the whole philosophy behind it, I think it's important to understand it. Europe, since the 1100s, has had this concept, which was incorporated into the laws of the state of Hesse in Germany, that European citizens have an inalienable right of privacy. So just like we have, the right to, the pursuit of happiness, they have this right to privacy. It's a fundamental right to them. And so sharing of information is a big deal for Europeans. And I don't know if any of the listeners financial professionals or somebody who has come into contact with maybe a European citizen who's trying to set up some sort of business or residence over here, but they are generally shocked and dismayed that we share so much information with our credit reporting agencies and other creditors, and we tell them our incomes, and we tell them our jobs, and we tell them all sorts of things, and they can't even believe it. I mean, it's just something. So the GDPR grew out of that philosophy, and it basically took over from a couple of regulations, or a couple of I should say laws that were in effect that were not quite as far-reaching. So what they wanted to do is create an EEA-wide standard that would sort of direct the the protection of information throughout this area. So that's a lot, and I'm sorry. And by the way, each of the EEA countries, or I'll call them states because they are nation states, they each have the opportunity also, just like our states in the United States, when there's a federal law, the states can enact regulations or requirements that are even more restrictive for the benefit of their citizens. So you have some of that going on too. And for instance, in Germany, there are, I believe, five regions or states within Germany. Each of them has its own, requirements and methodologies. And so delving into this kind of thing, it's just like in the United States. You certainly don't want to be caught, non-compliant with GDPR and not know which way you're going to turn, because it's very complex.
Wow. So it sounds like a lot to keep up with. So bringing it back or simmering it back down to websites in GDPR. I know I've seen like the little banners on the websites and things like that. What's your take on that? Like some people are confused by that or don't know where to start.
What are you referring to? People marketing GDPR compliance?
So like companies that are in the United States, small businesses, for example, they may have a website, and they may do marketing on their website for, maybe retargeting or various types of marketing to visitors of their website, right? So in that context, shouldn't they have something in their privacy policy, terms of use, and or some type of notification banner if they're going to use cookies or things like that?
Well, yeah, actually, very similar in level of difficulty of compliance. That is where the similarity between California and GDPR countries diverge. They're both similarly difficult. There are a few touch points that are the same, where you have to know what your under the GDPR, you have to have a reason to collect the information you are collecting or processing. So there's data controllers, who are people who are, so let me just explain this very, very basic function under GDPR. There's a distinction between a data controller and a data processor. So a data controller is someone like Petronella. Okay, so Petronella will collect information on its customers. And let's say Petronella hires an accounting firm to process financial information on for those customers. So the financial firm would be a data processor because they're doing something on behalf of a data controller. The controller is telling what needs to be done or directing traffic, sort of like a company director. they're setting policy and saying what needs to be done, but they may outsource some of their functions to these data processors who work in conjunction with or on behalf of the data controller. So similar, there's similar concepts throughout the world, which we'll get to in a minute. But let me get back to your question. So, data processors and controllers have to have, the controller has to have a reason for collecting the information. There has to be a contractual basis, or there has to be a law enforcement basis, or there has to be something like to fulfill, some sort of order from the customer or something like that. You have to have a reason why you're collecting this information from what they call the data subject. I actually like that term. Data subject is so descriptive that I use it even here when I talk about the United States, because people understand what I mean. So the data subject also has right to be forgotten. So you have to get rid of all your information on the data subject, which can be challenging in backups and things like that. They have the right to correct their information and to review it. So it's, in that regard, it's very similar to what California requires, but who's covered is different. And that's where I'm going to go with this explanation. I had to kind of give you that background. So not every company is going to be subject to GDPR. If you have a website, there's been some guidance from the European Data Authority over there about the interpretation of the GDPR. Thank you so much, after all the time. And so at this point, they're saying, well, if you're a data subject, and let's say you're a German citizen and you come here and you go to the hospital, well, you're here and you're giving your information here for healthcare. You're not necessarily subject to GDPR. There may be circumstances under which you would be, but you're here doing business here, getting services here. And indeed, the GDPR says the data subjects who have rights under GDPR are data subjects within the EEA, within the governed territory, right? And so what does it mean to be in there? I mean, so does that mean I have the same rights as an American citizen if I'm just like traveling over to Italy for a couple of weeks? Probably not. Of course, like any legal system, the data authority over there is not 100% clear, and they haven't sorted out. Now, if you had put the Germans in charge, they would slice it and dice it, and everything would be laid out in like minute detail. But, you've got the French in there who use a very elegant approach, kind of like our Constitution. Well, it should just, these laws should apply to every situation, and we'll interpret them based upon the facts at hand. So a lot of times, people are asking very definitive questions like, what is the rule? Well, that's where the lawyer answers come in. It depends.
Right,
what is the situation? Also, I will tell you how you can get into the GDPR crosshairs. You can be marketing. You can put marketing on your website that basically is targeted toward people that speak a certain language. So you're translating your pricing into GDPR country currencies. You are translating it into their languages or the languages most used in those countries. So that could be seen as doing business over there. The term doing business is not defined, of course, in the regulation. And regulations usually define way more, but this one doesn't. So it's still a little bit vague. But I'm just saying there's been some guidance lately that, if you're an American company, you're marketing in English, you're not necessarily, I mean, you're not knowingly, marketing to people all over the world. Unfortunately, our clients, they were an association, and they had members from all over the world. That was their thing. They were trying to get the global thought process in a certain industry. And so they knew, they knew that that's what they were doing, even though they weren't marketing with specific, translations or conversions of currency, or they didn't even use any foreign languages on their website. But they, by the nature of their business, they were within that purview. You see what I'm saying? So it's fact specific. So
if I've got a client that's in the nonprofit space, and they have a strong mission to change the world, and they attract folks that are in the European Union, right? Mm-hmm. Shouldn't they then have some notifications on their website in regards to a banner or updating their policies?
Yes, there would definitely be a reason, because they know they're attracting people all over the world and they're encouraging it, right? So I would say, in an abundance of caution, I would definitely do that. Now, see, there's where, like, for example, I keep picking on California. I'm sorry, California, but and California is really progressive in this area. But the thing is, they in California, their CCPA does not apply to nonprofits. So that's not the case with the GDPR. It applies to for-profit and nonprofit organizations. In fact, our client was a not-for-profit, but it was a rather large one.
Wow. Okay. So then I guess the question is, so something should be done. So then it seems like there's just so much variance in what to do. But I assume that if you do something, it's better than nothing. So I guess what should be their next step? Should they obviously do the basics with the banner on the website and tell folks what they're doing in regards to marketing and what data they're collecting and why, like you explained, you always have to have a purpose, right? So why they're collecting this information and how, what they're doing with it? Should that be kind of the minimum?
Yes, and if you go onto a website, you can take one that has a GDPR, privacy obligation, such as, let's pick on somebody who's sued like mad, like Facebook, or
right. or HubSpot, right? Like HubSpot.com, they have a GDPR.
Yeah. And you've got some others, Microsoft, Google. Go to their
the big companies.
GDPR disclosure and just take a look at how they do it. You're going to have, your cookie policies. You're going to have your reason for collecting the data. You're going to have a statement of EEA citizen right, people in the EEA. I say citizens, doesn't have to be a citizen. Could be somebody from Africa who's over there working, or it could be an American who's over there staying for an extended period of time. What that period is, only those people know. Only the regulators know, and they'll tell you. Fine.
So to be clear, in this basic example of a website, so if I'm a German citizen, for example, and I find this nonprofit website that's in the United States, in this case, let's say the East Coast, and there's some type of event, like I said, the mission is to pretty much change the world, that I need to be advised of what data is being collected from me and why, right? And what if I say no? Like, what if I don't want any of that data collected? Am I no longer allowed to view that website? Like, what's the extreme?
Well, you have the right to be told what is done with your information if you participate in that website. And if you disagree with it, then you do not have to visit that website, right? It's like if you don't like the movie that's on Channel 4, change the channel.
Right. But yeah, okay, that makes sense. But I guess, do you write in the policy, gracefully leave, or do you have to put a technical control that if they click the no button, then something happens?
Well, I think if you, if somebody clicks that they don't agree with your policies, then yes, I mean, it would be wise to implement a technical control to say, thank you for visiting the website. We understand you don't agree with our policies.
Have a nice
We
day,
hope
and then
you'll,
send them
yeah,
back to Google or somewhere else.
yeah. So there you go. I mean, because at the end of the day, if you allow that person in and they say they don't agree, then then you're basically putting yourself as the business owner or business operator at risk.
Okay. All right. Another question around this. What if a lot of folks would do what's called geofencing on their firewall, where, like, let's say you're a small insurance company or you're a mom and pop business, and your business footprint is only maybe 2 or 3 miles from your geographic presence, right? Your storefront. What if you put in place IP address and firewall rules to basically deny any traffic outside of your area? Maybe it's your little area, or maybe it's just your state that you want to accept, and then for everybody else, your website's not accessible. Is that something that could be an example of a control, even though it might be extreme?
Well, I'm going to throw this one kind of back into your bin, because technically, I know that you're very aware that an IP address can be tracked from a location, but that's not necessarily where that person is.
Right.
And for many reasons, that IP address may be hitting your website from a location where the person is not.
Right.
So, I mean, it's one control, right? I mean, it's one control. Say you nothing, no IPs from this area, but that's not 100% bulletproof policy. And maybe you can.
I understand. That's like one layer of the onion, right? But I always talk about the onion concept. I guess what I'm saying is, if we say in the policy, or Mr. Customer, the mom and pop's example that I gave, says, we only serve customers that are within a 3-mile radius, from us, blah blah blah, in the policy, right? And then we have our banner that, if you don't agree with this, we gracefully redirect you back somewhere else to, like, Google. And then, maybe we add this other layer with IP address verification. And yes, you're absolutely right. You could spoof an IP address, and people use VPNs and things like that. I guess my point is that, how far, in your opinion, does the small business need to show effort and steps towards policing this?
Well, I think, I think you go back to, do you know that people in these countries are accessing, your services or your products? Do you know that you're doing business with people like that? If you know that, then you probably and it happens on a regular basis. It's not, even though one is enough. But if that's the type of business you have, then you're going to have, a duty to look at the requirements of the GDPR. And one of the requirements at a certain level, they have sensitive information that they've identified in the GDPR. There's like certain information that's protected by the GDPR is way broader than what we normally see in the United States too. So if you're saying, well, I'm an opinion-based company and I just get people's opinions on different things, well, guess what? Opinion data under the GDPR is a protected category of information. That's not the case here in the United States. So here we're focused on social security numbers, which they don't have over there. They don't use things the way we use them. They have identifiers, but they don't necessarily use them the way we use them. There's still, things like, email plus passwords and things like that. But over there, you've got a much broader definition of information that is personally identifiable information, basically.
Sure.
So that's where people get a little, let me see if I can read this to you. So it says personal data. This is for purposes of this regulation. Personal data means any information relating to an identified or identifiable natural person, data subject. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, an online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. Wow.
That's a
lot. Yeah. Think about it. And so here's what processing means. Okay, so if you're processing data, and by the way, you can be a processor and a controller at the same time. So you're not just thrown into one bin, but like in the United States, if you're the controller, you got to notify the data subjects right away if you are notified of a breach. If you're a processor in that particular incident, then you have to notify the controller. So it's really the same kind of third-party structure that we have here under HIPAA and other places. But processing means any operation or set of operations which is performed on personal data or on sets of personal data, whether or not by automated means, such as collection, recording, organization, structuring, storage, adaptation or alteration, retrieval, consultation, use, disclosure by transmission, dissemination, or otherwise making available, alignment or combination, restriction, erasure, or destruction. So just about everybody is a data processor, right?
Right.
So, see what I'm saying? It's just really, really a lot.
Right.
It's really.
So is it safe to say that when in doubt, force the user to accept your policy or otherwise gracefully redirect them?
Well, yeah, for many reasons, and even people, working in the United States and only working with clients in the United States, you're going to need to make sure that people are okay with your privacy policies, because if they're not, you do need to redirect them, and most sites will do it. Go to any site and see if you can click no, I don't agree. See what they do to you. Make sure your cookies are clear. But really just make sure that, see what they do. But you have to agree with their way of treating you if you're going to be in their house. If you don't want to have what they're cooking up for dinner, then you need to go somewhere else for dinner.
Sure. Well said.
Unless you were important, like, the Queen of England or something, and somebody's going to do it just for you,
Right.
Doubt it, though.
So,
and here, let me see if I can send you, lawfulness of processing. I want to cover this. It's very important. Processing shall be lawful only if and to the extent that at least one of the following applies. A, the data subject has given consent to the processing of his or her personal data for one or more specific purposes. So there's your consent, right? And then B, processing is necessary for the performance of a contract to which the data subject is party, or in order to take steps at the request of the data subject prior to entering into the contract, C, processing is necessary for compliance with a legal obligation to which the controller is subject. D, processing is necessary in order to protect the vital interests of the data subject or of another natural person, like providing somebody's medical details to emergency personnel, in other words. E, processing is necessary for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller. And then F, processing is necessary for the purposes of the legitimate interests pursued by the controller or a third party, except where such interests are overridden by the interests or fundamental rights and freedoms of the data subject, which require protection of personal data, in particular where the data subject is a child. Now, what I will say is this whole thing about the interests of the controller being overridden by the fundamental rights and freedoms of the data subject. One of those fundamental rights and freedoms is the right of privacy. So you have to balance that, and that's where companies in Europe, depending on what level of processing you're doing and what types of things you're collecting, you may have an obligation. I mean, it's always a good idea, but you may have an obligation to perform a data privacy impact assessment, which is a DPIA. And so it's sort of like a security risk assessment, but this one covers privacy, and it talks about, it basically takes a data map, okay? So you got your data map, right? Like, what are my business processes? Where do I take the data? When I get it, what do I do with it? Do I store it? Where do I store it? Then I use it. How do I use it? Where do I use it? How do I get it there? What are all my protections, along the way? And when I'm doing each of these processes, like I'm providing the information to my credit card processor so that I can bill this person, right? Well, that's a legit interest, right? I'm doing that in order to fulfill a contract with the data subject. So that's a legit interest. But what I have to do is go through and list all of my processes and figure out why I'm doing each of those processes and what's a really good reason under the GDPR why I need to do those processes and what sort of protections I have on them.
So is that process that, I think you said DPIA, right?
Yeah, data privacy impact.
So
assessment.
Is that something that you would do for somebody, or is that something that they would self-assess or on their own?
Well, it doesn't have to be done with a third party. So companies can, or people can do that for themselves. Generally, they would like to know, at least the first time, they would like to know whether they are doing it right or not and interpreting the law correctly. So we can get involved with that. And sort of set up the framework for them. And then as they're, let's say you add some sort of a business line, or you decide to do something differently in your business and you're processing data differently, or you're marketing to new places and you're sharing information with new companies like an AI company or, a blockchain company or something, then you've got to redo your DPIA to make sure that these new things or changes are still, that you have some basis for it, right? And that the things that you're doing are not overridden by the interests and fundamental rights and freedoms of the data subject.
Wow.
And you literally have to write this out in the DPIA. You literally have to say, this is because of this. This is, our interest in doing this are overridden by their, whatever. You have to say, we have this as a basis. And, basically the best thing to say is the data subject is agreeing to all this because we're doing it in order to do the business that we're doing with the data subject.
Okay. So it sounds like most businesses that would work with somebody from the EU and be subject to GDPR should definitely follow that process and go through that DPIA.
It would be very interesting to do, yes, and very, very good to do as a, it's like, do you have to put, are you required by law to put anti-malware on your endpoint? No. Is it a good idea? Yeah.
Yeah, and that's getting in that equation or that example, that's becoming, more of a political issue as well. I mean, especially around the CMMC, where you're going to have to put that. I mean, they don't tell you which brand, make, or manufacturer you have to put on there, but you have to show supporting evidence that it is on there.
Well, right. I mean, that's a terrible example, probably because even some states are talking about reasonable security measures, required in their privacy laws. So, obviously that's going to be required, but, it's like, it's a good idea to, lock your deadbolt as well as your little, doorknob lock. So it's just, it's a defensive measure on your part against, overzealous regulators. And if anybody has been following any of the litigation with, Facebook and the Schrems cases. Schrems is a guy from Austria that disagreed with Facebook's, policies and their processing of his information under GDPR. There was Schrems 1 and Schrems 2, and as a result of Schrems 2, the entire basis for transferring data of European data subjects to the United States was absolutely decimated. The European Court of Justice decided that the systems whereby we were doing that, the privacy shield was not sufficient, and basically it was based on our Section 702 collection of intelligence data, just doing these big scoops of data and sorting out the things we actually wanted. And Congress over here keeps passing that thing, and the Europeans are like freaking out because when we go looking for bad guys, we just scoop up older people's information. They don't like that. I mean, I totally see it, but it sure makes it difficult. So now you're kind of looking at putting in place, these what they call standard contractual clauses. So if you're going to have, cross transatlantic, transfers like that, you're going to have contractual clauses in your data processing and controlling agreements, so that you are deemed to have adequate protections for European citizens. And that's a whole nother, the standard contractual clause is a whole nother story. But just for the basics for GDPR, I would say, it's a good idea to do a privacy impact assessment, data privacy impact assessment. Great idea.
Oh, it sounds like it would give at least some clarity around how GDPR could affect your organization, and what jobs to be done need to be addressed. One thing that came to mind, going back to the IP address, and obviously spoofing of IP address is easy to do, VPNs, IP address, and the very nature of the internet was not built around security. So I'm wondering if if it's so easy to spoof an IP address and use a VPN and things like that, how do you really know who's visiting your website and where they're coming from anyway? You know what I mean? So it sounds like that would be, an exercise that's hard to prove. But it also sounds like you, as a website owner, if I keep going back to websites, but I mean, using that as an example, it sounds like you should definitely have the GDPR information in the policies, the privacy policy, the banner, et cetera, and pretty much ask every time somebody comes to your website if you agree or not, and then gracefully redirect them away if they don't. And then I think once they raise their hand and fill out like a contact form, and you do know where they are and where they live, providing they give you factual information, then you probably have more obligations to obviously safeguard that information.
Yeah, I think, and you gotta be real careful about what you're collecting and what you're keeping if somebody, disagrees, right? So that's the other thing, get it off. It's like, hurry up, it's a spider. It's kind of like that. I was gonna share with you one other thing. Okay, so the lawfulness of processing is addressed in the GDPR generally, okay? There's been guidance on this, but, we can't get in the weeds. I'm just trying to give you the top level kind of perspective. It says, processing shall be lawful only if and to the extent that at least one of the following applies. A, the data subject has given consent to the processing of his or her personal data for one or more specific purposes. So basically, you're disclosing to the data subject on your site, with your GDPR notice that, here's what we do with your data, right? Then they agree or don't. B, processing is necessary for the performance of a contract to which the data subject is a party in order to take steps at the request of the data subject prior to entering into a contract, right? And then you've got, all these other things that we went through. So again, with respect to the notices and the agreement, first you have to tell them what you're doing. That's why I'm suggesting you start with your data map and just your own business processes. Probably most businesses, unless you're a gigantic enterprise, you probably have a succinct number of business processes that you engage in. You probably have things that you do. You might have, several things that you do, like we do, but we do a lot of the same thing. I mean, we take in people's information through our email programs or telephone calls. We write down notes, on our computer. We store them. Where do we store them? How are we protecting them at all these different points? What are we doing? And then, of course, that comes into the, the fundamental triad of security, confidentiality, integrity, and availability. You've got to make sure you're protecting that in your data, and you have to pay attention to the technical, physical, and also the administrative, or your policy and procedure aspect of security of the data. Because if it's not secure, it won't be private. Somebody's going to dox you and put out your information on the internet, a la Capital One breach. Yuck.
Yeah.
Wow. So that's what you get. And then one person calls their data protection authority in their country, and you are just tearing your hair out.
Jeez. So do you have any tips or suggestions for, it sounds like the assessment process is a good place to start. Is that accurate, or any other insights?
Well, I think even before you get there, I think it's, I think it's important to understand what business you're in with respect to people in the EEA countries, right? Are you even governed by those? For example, a very large hospital system here decided they weren't. They're like, we're not. And the reason they decided that, the basis for their reason, didn't matter how big they were or small they were. It was just that they treat people who are in the United States and they're here getting information. We're not transferring information across the Atlantic, and we're not having to prove the adequacy of our controls. We're collecting information here in the United States. That was their take on it. Now, if somebody is sending over information from their doctors or whatever in the EU, there may be an argument, but it would be factually based, right? So you may not really be marketing to European people. You might get them every once in a while. You're just marketing, and you're thinking you're mainly dealing with Americans or whatever. But that is something that I would say talk to somebody who knows something about the GDPR and has a little bit of knowledge about the different cases that have arisen since it has been enacted in 2018, because that will, guided by that perspective, you'll be able to make an analysis, and nothing is going to be perfect. I'm going to try to emphasize this, until a regulator pronounces whether you're good or not. Nothing is black and white. Are you needing to comply? Are you not needing to comply? Most U.S. businesses that are doing business locally, they don't have an obligation. But if you know that you regularly do business with people outside the country, you may have that obligation. And at that point, I would definitely go to your data mapping and your business process mapping, which you should have at all times anyway, even for your United States risk assessments that Petronella can help you with. And at that point, analyze it through the lens of GDPR, because you probably already analyzed it for the United States compliance, but you need to now look at it from a European perspective, because as you could see, the types of information that are protected it's a much broader group of information.
Absolutely. So it, further emphasizes the need and importance of annual security risk assessments, and then branching that out into GDPR and other regulations that you might be subject to. But it sounds like, when in doubt, at least make some effort instead of assuming or doing nothing.
Well, yeah, and here's my thimbleful of advice for anybody that asks, a cocktail party or otherwise. I usually tell people, just absolutely know what kind of data you're collecting and where your data is and how you're protecting it. Encryption is a fabulous tool. It's a get out of jail free card in most every jurisdiction. However, that depends on whether your hashing is strong enough, et cetera, blah, blah, blah. But, and you're
not saving the public keys on your hard drive or somewhere else.
Or putting your passwords on a Post-it note, on your desk, and then leaving for, Europe. What I would say is just know your business. It's become a business function to know your data types, know where your data is, and how you deal with it. So that's a business function, just like how much money you have in the bank and how much income you can expect, and what your budgeting requirements are going to be for the year. You just kind of need to do that with your data also. It is an asset, and it's valuable when it's stolen too, because it's going to hurt you. It will hurt you to the extent of its value and more.
Awesome. Well, this has been awesome. I appreciate all your insights and discussion on GDPR. So how do folks reach you should they want to do the assessment process with you?
Yeah, if somebody wants to speak more in more particularly about their particular situation, you can feel free to call me directly at 813-220-3000. And also we have a website, which is SHASTEEN, P as in Paul, ERCY.com. So that's ShastenPercy.com.
Awesome. Thank you, Lisa. I appreciate all the insights and the shedding of light on this wonderful topic.
I don't know if I created confusion or shed light, but yeah.
Well, thank you again. I appreciate it.
You're welcome. All right. You too. Bye-bye.
Bye.
Thanks for listening to yet another episode of Cybersecurity and Compliance with Craig Petronella. Listen to all of our podcasts on Apple, Google, and Spotify. Visit us online at petronellatech.com to book a meeting with Craig about your business.
Thanks for listening to the Cybersecurity and Compliance Podcast with Craig Petronella. For other episodes and more information, visit PetronellaTech.com. Also visit our other websites, ComplianceArmor.com and BlockchainSecurity.com. Don't forget to like and subscribe. Thanks for listening, and stay secure.